let's talk about breach. Breach seems like a nasty word, but when we're talking in a commercial context, when we're talking about a commercial lease or a contract of commercial subject matter, there's such a thing as an efficient breach. Breach doesn't always make you the bad guy or girl. Breach could simply be it's in your best interest to not follow this contract anymore and pay the damages. Specifically, let's give you an example. In a commercial lease where the lessee wants to get out of the lease, perhaps breach makes all the sense in the world to put the landlord on notice. Hey, I don't want to continue on with this lease. I'm going to start marketing the space and see if I can assign it. And oh, by the way, you do the same. Because what does a landlord have to do? They have to mitigate their damages. And so when we're talking about civil actions, when we're talking about breach, specifically contract breaches, it's important to remember breach doesn't always mean bad guy. Sometimes breach is an efficient breach and a party's in better shape after the breach. Before you breach, though, it's always important to read the contract, understand what the downside is and what the maximum amount of damages you're facing, and what the possible upsides of that breach are. Also, I think it is important that if a breach is in the future for a business client, that you communicate clearly with the other party what your intentions are so that you can mitigate the damages for them and make sure your breach is as efficient as possible for you. Breach isn't always a bad thing.